Good day to you, Dr. Mukris. We are from Lee & Partners and we are proud to present all the facts and 2 pieces of key evidence in 12 Angry Men.
The 12 Angry Men movie concerned regarding the murder case where the accused was charged with the first-degree murder of killing his own father. Most evidence standard was circumstantial, but there is also one direct evidence that was found in this case. The murder took place around 12:10 a.m. of the night according to the testimony of an old man who lived downstairs under the room of the accused. He claimed that he heard loud noises that sounded like a fight and heard the accused yell, "I will kill you," to his father. A second later, he heard a body hit the floor, ran to the door, opened it up and saw the accused running down to the stairs and out of the house. Not only that, a woman who lived across the street claimed that she saw that the accused stick the knife into his father through the last 2 cars of the elevated train. According to the people in the apartment, around 8 p.m. of the night, they heard the accused quarrel with his father. They also claimed that they saw the father hit the boy twice and finally they saw the boy run angrily out of the house. A material switchblade knife found at the body was indeed the same knife that the accused bought in the neighborhood junk shop, as the storekeeper testified that the knife was in fact one of its kind. The accused friends also contended that they saw the accused with that switch knife on the night of the killing around 9:45 p.m. The knife was identified as the same knife as the deadly weapon in the court.
One of the pieces of evidence against the accused in the film is the evidence of motive and preparation to commit the offense. This evidence is circumstantial evidence in supporting a conviction. According to the testimony from those people across the hall, they testified that there was an argument between the father and the accused around 8 o'clock that night. Further, juror number 8 pointed out the accused's father beat him up regularly since the accused was 5 years old. The accused may have the desire to exact vengeance on his father for years of abuse and also revenge himself on his father for hitting him twice at the day of the accident. Therefore, the motive of the accused was established and determined. Besides, the preparations of the accused of committing the murder can be seen from the fact that the accused has purchased a knife from the store at that night of accident. In the case of public prosecutor versus Sajid Kaur Anak Perempuan Najar Singh, the court in this case laid down some examples of this circumstantial evidence. For example, the motive of the accused, acts preparatory to the commissions to the offense, presumptions of the facts, and so on. Therefore, the motivations for the murder due to the accused's passionate hatred of his father and the preparations of the accused to murder by buying a switch knife at the neighbor's store after being punched by his father is considered circumstantial evidence in sustaining the convictions. In the aspect of the relevancy of this evidence, Section 8, Subsection 1 of the Evidence Act 1950 allows for the presentations of evidence of facts by demonstrating the motive or committing the crime and preparation, provided that such motive and the preparation influences by or is influenced by any facts in the dispute or relevant facts. The evidence of motive is especially relevant if all the evidence in the case is circumstantial evidence. This has been affirmed in the case of Datuk Mohtar bin Hashim and another versus PP. The court held that although the motive is not required to be proven in the murder case, it would strengthen the prosecution's positions if it could be shown. Further, according to the Courts of Appeals decisions in Muhammad bin Duraman versus Public Prosecutor, the motive is admissible as corroboration evidence to the fact in issue with the prerequisite that the accused possessed the necessary intent to kill when considered alongside with other evidence. Evidence showing preparation may also be presented under Section 8, Subsection 1 of the Evidence Act 1950. Acts of preparation includes anything done together, buy, procure, repair, or remove obstacles before a crime may be committed. All crimes can be broken down into 4 distinct phases as established by the court decisions in Tangia and another versus PP. To commit a crime, one must first have the purpose to do so, prepare and plan for its commission, make an attempt to commit, and ultimately commit the crime. Even though the preparations to commit a crime in or of itself does not constitute a criminal act, the act of preparation is relevant evidence that can help to prove the facts in issue.
Under the English common law principles, when a case hinges on circumstantial evidence, the motive may be relevant. This can be seen in the case of Udaypal Singh against State, where the court held that the chain of evidence is complete if it shows that the accused had a strong enough motive to commit the crime. Further, the Supreme Court ruled in the case of Chuni Lal against State of Uttar Pradesh that an accused could be found guilty if his motives for the crime was to take vengeance on the deceased or to steal their property. From the cases cited, it must be noted that under the English common law principles, when there is no direct evidence and the court must infer motive from the facts, the question of motive becomes extremely important. The fact that he made preparations that are related to his act is obviously important for the purpose of proving that he did it, when there is question as to whether or not he has done the act. Another situation can be best illustrated in the case of Apu against State, where the 4 accused were involved in the offence of burglary. The 4 accused gathered to plot and plan the crime. The accused in this case brought an iron bar and a set of pincers. This evidence will show the accused's preparation was admissible. Therefore, it can be construed that under the common law principle, any evidence that points to the accused's preparation of the offence is admissible. All in all, by referring to Section 8, Subsection 1 of the Evidence Act 1950 and English Common Law Principle, the circumstantial evidence of motive and preparation is relevant to the charge. Motive can be relevant because it can lead to the inference on whether a fact in an issue exists or not. Besides, the fact that he made preparations, which he bought the switch knife after the conflict, that are related to his act is certainly relevant and important for the purpose of proving that he committed the murder. Hence, the evidence of motive is relevant and admissible per either Section 8, Section 1 of the Evidence Act 1950 and also the English Common Law Principle.
The second piece of key evidence that is relevant to the charge is the evidence that is in favor of the accused in the firm, the testimony of the woman across the street. This oral evidence forms part of the direct evidence in the prosecution case. According to the woman's testimony, she saw the murder committed in which the accused raised his arm over his head and stabbed his father in the chest. The woman, who was having insomnia that night, looked out the window and saw the act of murder through the last 2 cars of a passing out train. Nonetheless, juror number 8 raises doubt on the evidence of the woman, who may have worn spectacles as she had the marks on the nose bridge, same as juror number 4. As the woman was attempting to sleep at the time of the murder, she was likely not wearing her spectacles and hence could not see the murder clearly. She could not have discerned the accused's face from across the street and while a train was passing. The credibility of the woman across the street was then called into question.
In respect of the relevancy of the facts aforementioned, Section 11B of the EA 1950 provides, facts that are not relevant by any other means are relevant and admissible under this section if, by themselves or in conjunction with other facts, they constitute the existence or non-existence of any fact that in dispute or relevant fact very probable or improbable. The fact that the woman across the street has a myopic problem and therefore could not get a clear view of the murder was in fact highly improbable with the fact that she claims that she actually saw the boy killing his father, and this fact is relevant under Section 11 of the EA 1950. This has been affirmed in the case of PP versus Dato Sri Anwar Ibrahim, where the judge had in this case referred to Saka on evidence and ruled that the court should exercise its discretion and examine whether or not the connection between the fact that needs to be proven and the fact that needs to be given in evidence is so close or immediate that it makes it highly improbable that the two can exist together to determine whether the fact is of relevance. At this point, the argument is that a woman with vision impairment may have believed she witnessed the kid committing a murder, but she may have merely seen a blur since she did not wear her glasses when she glanced out the window. It is highly improbable that she could have identified the person killing the deceased as the boy.
Therefore, this discrepancy had made the woman's testimony highly improbable, and the fact aforementioned, not otherwise relevant, is relevant and admissible under Section 11B of the EA 1950.
From the perspective of the English common law principle, there are facts which are admissible because of their logical connection to either proving or disprove the primary facts or facts in issue. By referring to the case of Carroll versus Rockhart, a collateral fact itself must be proven by evidence that is sufficiently conclusive to give a credible presumption or inference as to the issue that it is questioned. For instance, the woman had a marking on her nose as a result of wearing spectacles was possible and eyeglasses wearing woman. With that being the case, it is reasonable to believe that she wasn't wearing her glasses when she was in bed trying to sleep. Hence, the testimony of the woman had in fact raised a doubt whereby she might only saw a blur instead of the boy killing the man. In addition, as stated in the case of Buya versus Ramkali A, this provision admits only those facts if they are accepted as evidence will carry a large deal of weight in convincing the court of the presence or non-existence of the facts in issue. For the above mentioned principles, it must be noted that the facts when the woman was to recognize a person standing 60 feet away from her at night without using her eyeglasses, her vision was called into doubt, and if assuming they are admitted in evidence, will be a great weight in bringing the court to a conclusion that the existence of facts where the woman saw the boy killing his father would be highly improbable. By referring to the principle and cases cited above, it is noticeable that the law in Section 11 of the Evidence Act 1950 is modelled on the English common law position, in which both stand on the same position when admitting facts that are not otherwise relevant are relevant if they are contradict with any facts in issue or relevant facts. To conclude, the facts that the woman have myopic problems and does not have her glasses on could not possibly witness the scene the kids killing his father across the street. This is certainly a relevant and admissible evidence based on Section 11 of the Evidence Act 1950 and common law position as well. Therefore, this fact was in fact a piece of evidence in favor of the thesis.
That's all from us. Thank you.